record today as it relates to the father or a pretrial. May I have the names of our participants, please?
Lee Heiss, lawyer, guardian ad litem.
Ms. Naja Thomas, counsel for the department. Mr. Darian.
Christopher Farian for the department.
Ashley Hanson-Grimes on behalf of Father Michael Mulholland, who is seated in the courtroom to my right.
Michael Mull.
Okay, we do also have Ms. Melanie Mulholland logged in. Can you hear us okay?
Yes.
Okay, you're welcome. All right. I do have a proposed court report. Were you thinking this was going to be like a review type hearing as well, Ms. Thomas?
Yes, Your Honor. It was my understanding at the last pretrial that this court was really looking for whether or not there remained a substantial risk of harm to the children that would warrant the that would warrant us keeping this petition in front of this court. So the court report just, what I'm hoping the court finds is what services were recommended, and then what is happening with those, and then this court can make the determination as to whether this petition remains necessary.
Good. Well, let's get to it then. Report, Ms. Heiss.
Thank you, Your Honor. I visited with the children face to face, and I'm going to repeat again that this is a family with a lot of strengths. These kids are excelling in school, socially, very balanced family. Their mother is home with them on the hours that they're not in school, and she's very involved and can finish their sentences, and she keeps their schedule. They eat as a family. They have a wonderful home and pet, and my research looked through my court regarding Mr. Mulholland, and I noted that the victim advocate is active with M in good hands, and the mother reports that they call and say, this is where to meet me, this is what's happening with the case. So I'm happy that they made that connection. The jury trial is either late April or early April, so that the family will get through spring break, and then the child is anticipated to testify. So the bond conditions remain in place, and the children have no contact with their father, and mother does not need to be convinced of that, because I think she's well invested in the best interest of the children, and she knows that that's the rule right now. The children are miss having the dad in the home. There was recently a car that broke down, and I said, if dad lived here, would that normally be something that he would help mom with? And they said, no, he'd probably break it even more. But they smile, and they talk about their dad being, they were a real intact family before this drinking issue and these other issues came up with dad. So they're on hold. I think that's the best that we can say, is that they're on hold, waiting to find out what happens with dad and what their family will look like without that resource, without that, it's like a four-legged chair and one of the legs is missing at this point. But they are, I think if the case were dismissed, they would have less interference from Mr. Farian, myself, and I think that would benefit the family. I read Mr. Farian's report showing that the OT that was recommended for this little girl, so many school officials say that is not something that looks like 504 plan IEP, something like that, to help the child. This little girl is really advanced in so many categories. So in the silo of a mirror opposite, she has a little bit of trouble doing a mirror opposite. I mean, the mother can tell you diagnostically everything about this child, and she's comfortable letting that develop on its own and not calling it delayed, and because she has so many other strengths. She does her spelling tests and her math tests. She's doing addition and subtraction, and she has so many other strengths. She's able to play online videos, so she doesn't think it's affecting the child, and that the school doesn't support OT in school, so it would have to be an out of school situation. So anyway, I think that the services have left this family strong enough to continue through the trial, and then depending on not just the jury trial, but also the sentencing. I think we should make a determination what to do with this case at that time. I think mom is kind of waiting to see what the family dynamic is gonna look like after that trial too. So that concludes my report, Your Honor.
Thank you. Ms. Thomas?
Thank you, Judge. If Mr. Farian can be sworn in to provide the update.
To our witness stand this morning, Ms. Thomas.
Mr. Farian, you have been the ongoing CPS worker with this family for quite some time, correct?
Correct, yes.
And during this brief review period, I suppose we'll call it, you have the opportunity to meet with the family?
Yes, I've met with both children and mother.
Okay. And one of the things the court wanted us to explore at the last pretrial was whether this family needed any more resources, and whether there remains a need for this petition to continue to go forward. In your, you drafted a report for today, correct?
Correct, yes.
And are there any updates or modifications you need to make to that report?
No, not at this time.
Okay. And in your report, you review some of those recommendations as it relates to the daughter in this matter. Can you just briefly state where the children are in their services, if they need any more? Is there anything else the department can do for this family?
Yes. So I know that the court had asked, based off of two recommendations through the CTAC that was completed back in August of last year. One being mom grasping some additional services specifically, and I don't have that in front of me, but a specific program that may benefit her, especially dealing with children with trauma. There was also the opportunity, it's an 8-week course. Mother didn't want to do that only because of the fact that kids are busy. They're in sports, they're in extracurricular activities. So she didn't want to take away from that. However, there was an opportunity to do that online at her own leisure, which she has access to, which she's able to do for free. She had indicated that she would contact the counselor for MM to discuss what particular topics maybe would benefit her if she didn't saw that was needed, and she can access those and complete the courses on her own. As for the OT that Ms. Heiss had indicated, yes, I spoke to this in a collaboration of the teacher, MM's current teacher, the counselor, and the principal at that school regarding the actual issues that are listed in that CTAC, which one of them was writing. I think it was a visionary type of thing. They don't see that those are barriers to her whatsoever. She is an outstanding student. Actually, they were taking a little bit off, they were caught off guard by the question. They weren't prepared for that. I would like to make mention though, if you go to the beginning of that CTAC assessment, there was indication by the person who did that assessment that she was shy, that she wasn't really engaged in the beginning. And I'm not sure at what point that particular thing was done in the course of that day. And maybe, there some of that shyness was coming out and just not answering or not sure in her own insecurities at 7 years old may have played a role in that. And I am speculating on that. So, but the school that has seen her this school year does not indicate that there are any issues. Lastly, MM is continuing her counseling. She only goes once a month, and then it would be maintenance. If there was some sort of a crisis or something like that, then she would be able to get it. Other than that, they have no other services from the department. Mom's not indicated that she needs any more services at this time.
If this court were to dismiss the petition, is there any risk of harm to the children?
Based off of the information that I have, no. The no contact order remains in place. And as Ms. Heiss also alluded to, speaking with mom, she would continue to follow that, pending the outcome of any criminal case or criminal decision.
Okay, thank you. Your Honor, I have no further questions for Mr. Farian and ask that the court report be accepted by the court.
Just a question or a clarifying question. It may have been a minute since I was involved with this court, but is the 7-day court rule where we're supposed to have notice of the court report or any updates to it still in effect?
Yes, do you not have a copy of the report?
Oh, I didn't get it until Monday.
Oh, okay.
So I was not able to seek my own independent evaluation of anything that was provided. And so I just would like to make a clear record of that and maybe ask Mr. Farian before submitting the report into evidence if there was a reason for that delay. Mr. Farian. Go ahead.
Okay, thank you. So yes, originally, when I had received this, I thought it was a continuation of the pretrial and that I was supposed to find that particular information out and then present it as a continuation. I did ask Ms. Thomas last week. So that is my error thinking that it was a continuation and not realizing that I should produce another report. So that is what I did. It is pretty much the same report that was produced back in December with the 2 additions to it.
Your Honor, I don't have any objection to the court receiving the report, but I do have some questions for Mr. Farian outside of the question I just asked.
Okay. Any objections, Ms. Heiss?
No, thank you.
Thank you. All right, the report is received. You may proceed with your questions, Ms. Hanson-Grimes.
When we were here back in December, the court asked you to make the referrals that were suggested in the August trauma assessment. Is that correct?
Correct.
Why weren't they made prior to that?
That was an oversight, and I think I indicated that on the record that I didn't see that as part of something that needed to be done at that time.
Okay.
Go ahead. No.
And have there been any services or any recommendations that have not been followed through for B?
No.
Okay. And he, along with M, were both discharged from their therapist back in November. Is that correct?
That is not completely correct. Yes. B was discharged. If you go back to, I believe, the previous court report, and I'm not sure if it's the one that you have with all the exhibits attached. There was a letter in there from her current therapist at the time, Destiny Buckley, who was going on maternity leave. So she turned that over to Ms. Abbott, who took over from there. Ms. Abbott was to do everything as needed and or continue with therapy as saw fit. And if you don't have a copy of that, I believe I do have one with me currently.
Is there, is that the November 6th letter from Destiny Bucklow?
I believe so, yes. So she was discharged from that one, but she was continuing with Ms. Abbott while she was on maternity.
And that would be the once a month maintenance therapy?
Correct, yes.
Okay, so when Ms. Abbott testified here in December and she said she was no longer a patient and she couldn't see her, so that was not true then, or?
I don't recollect her saying that.
Yeah, she said she wouldn't give us any information because she was not her patient any longer.
I can't speak to that then.
Okay,
I don't know why that was said, so.
So to your knowledge, she is seeing, Ms. Abbott is seeing M once a month for maintenance therapy. Okay, is the previous therapist, Ms. Bucklow, not back from her maternity leave?
To my knowledge, she's not back from.
Could you provide me, if this court decides not to dismiss this petition today, could you provide me with a list of dates and times that she has seen her therapist in the last month or the last several months?
Sure.
Thank you. You admit that there is still a no contact order through Lenawee County Circuit Court as it relates to this matter?
To my knowledge, yes.
Okay. And there is nothing in your investigation that has indicated that that no contact order would not remain in place going forward until the matter is resolved. Is that correct?
Correct.
Okay. And are you aware that my client provides financial support for the family still?
Yeah, excuse me. I should have said it that way. Yes, I am aware that he has provided as an.
With the no contact order in place, you recently just testified that there is not a substantial risk of harm as long as that remains. Is that correct?
Correct.
Okay. And so at this point, do you have any objection to the court dismissing your petition?
My only thing would be based off of the DHHS policy that we continue with the petition. However, other than that, I've answered that question. request.
Okay, thank you. I have nothing further from Mr. Farian.
What is the circuit court case number, if you know? Do you have any questions, Ms. Heiss?
I have no questions.
Thank you for your testimony. You return to your seat. All right, any other witnesses today, Ms. Thomas?
No, Your Honor.
Ms. Hanson-Grimes?
I have no witnesses today, Your Honor.
Ms. Heiss?
I have no witnesses, thank you.
All right, any comments, Ms. Thomas?
Your Honor.
I'm sorry, I only caught the last bit.
No, Your Honor. I will leave you to your findings. I think that today's record speaks for itself. Thank you.
Ms. Hanson-Grimes?
Yes, Your Honor. You asked you asked us all to consider this question when we were before you in December. And I think that Mr. Farian has done his job by making sure that the services that were recommended have been provided to the children. But in December, he also testified that the main reason he was keeping the case open was to monitor the circuit court case. He can continue to monitor or not, but there is no substantial risk of harm to the children as long as the no contact order is in place. And although we've waived the suitable timeframes, this case is approaching 1 year. We're taking up time on your docket, and we're not any closer to having a trial in this matter. I think that at this point in time, I will remind the court that my client is innocent until proven guilty, and that if, and it's a big if, he were to be convicted, the department would have a right to bring this petition back before you. But when he is acquitted, we would allow this family to continue to go on their way without any further interventions. As Ms. Heiss says, these kids are doing remarkably well. And that, I feel that speaks for itself. They have a lot of supports, they have a lot of strengths, but they want to be normal kids. They don't want to keep talking to caseworkers. They don't want to have attorneys. And I think that we have an opportunity right now to do that. So I would ask that you dismiss this petition today without prejudice, clearly. And if there was a need to bring this back before you, then the court could address it at this time. But at this point, there is no additional services, and it's testified by Mr. Farian, no substantial risk of harm to these children that would allow us to keep it open.
Okay, Ms. Heiss?
I do believe it's in the best interest of these particular children that this is dismissed, and that the agency, as an ongoing matter, watch for the trial that comes up in the sentencing if there is one. Thank you.
Thank you. The court finds all interested parties were given notice for purposes of today's hearing. I appreciate the work that was completed on the case by Mr. Farian. It certainly constitutes reasonable efforts and meets the obligations necessary in the statute, as well as Ms. Heiss. I would agree that the bond conditions do ensure against any risk of harm associated with the outstanding allegations, and the resolution of that, as Ms. Hanson-Grimes pointed out, one way or the other will certainly dictate what happens with this family moving forward. Regardless of this particular petition, the department would have always the option to refile, but without an imminent risk of harm to the children, as well as given the age of this case and the potential for continued aging without resolution, there's no need for the court to maintain the pretrial status. This petition was filed June 21st, 2023. We are well past the required date for trial, which has been adjourned a number of times as being in the best interest of the children both, but namely because it seems unreasonable to require this child to testify more than once, especially in light of the bond conditions providing security against any contact, as well as the fact that all needs have been met and all services have been extended by the department to the best of the ability of the caseworker, as well as the needs of the family. I will dismiss the petition.
Thank you, Your Honor.
Thank you, Your Honor.